Civil law. And for today's story, we turn attention to the U.S. Supreme Court, which has once again ruled on the issue of immigration and stopped the Trump administration from deporting people willy-nilly. This is the case of AARP versus Donald Trump on an application for injunction that was decided by the U.S. Supreme Court again today. So basically, long story short, there continue to be rules. There continue to be rules on deportation. Look, I have no problem with deporting the illegal people. Deport them all. That's great. Let's do it. Let's close the border. Let's do it. Let's do it. It's fine. Let's do it. Let's have rule of law. I'm down for it. I'm down like a clown, Charlie Brown, but I still want to do it by the rules. The Trump administration could deport the people following rules, but the Trump administration has been looking for some express passes. They don't want to follow the rules for standard deportation. They want to do the express pass thing. And the Supreme Court's like, no, you can't do the express pass thing. It's not happening. And they keep having to remind them of this basic lesson. So, that's what it is. So let's go ahead and read this case and see what it has to offer us in terms of the legal analysis. Let's go ahead and get started with this. This is a per curb decision, which means there is no listed author. The president invoked the Alien Enemies Act. We remember that law. We remember that. That's the law that the president said, hey, if you're in a fight with us from a different country, we can just deport you with the express pass. And the Supreme Court has said, no, it doesn't quite mean those things. It's not what it, no. He invoked the Alien Enemies Act to remove certain Venezuelan nationals who he says are members of Tren de Aragua, a designated foreign terrorist organization. The applicants, in this case, are two detainees identified as members of the organization and a putative class of similarly situated detainees located in the Northern District of Texas. All the alleged TDA members in the putative class are currently being held in detention facilities. In the application before the court, the detainees seek injunctive relief against summary removal under the AEA. So again, it's not that we can't deport them. Is that we can't deport them summarily. We can't deport them without process. We can't deport them without a hearing. There are rules. And we keep having to learn the rules. Okay. Let's learn a little bit more about the facts of this case. On April the 17th of 2025, the district court denied the detainee's motion for a temporary restraining order against summary removal under the AEA. The detainees alleged that hours later, putative class members were served notice of AEA removal and told they would be removed tonight or tomorrow. On April the 18th at 12:34 a.m. Central Time, so just over midnight, the detainees moved for the emergency TRO. At 12:48 p.m., about 12 hours later, the detainees moved for a ruling on that motion or status conference by 1:30. At 3:02 p.m., they appealed the constructive denial of the emergency TRO to the Fifth Circuit. The detainees also applied to this court for a temporary injunction. We understood the government to be asserting the right to remove the detainees as soon as midnight Central Time on April the 19th. The government addresses the detainees' allegations on April 18th only at an evening hearing before the District Court for the District of Columbia, where detainees had sought separate relief. The government guaranteed that no putative members would be removed that day, but it further represented that, in its view, removal of the putative class members as soon as the next day would be consistent with due process obligations and reserve the right to take that action. So, not that day, but maybe tomorrow. We're going to remove them. Evidence now on the record, although not all before us on April 18th, suggests the government had in fact taken steps on the afternoon of April 18th towards removing detainees under the AEA, including transporting them from their detention facility to an airport and later returning them to the facility. Had the detainees from the United States to the custody of the foreign sovereign on the 19th, the government may have argued, as is previously argued, that no U.S. court had jurisdiction. So we can't help noticing that you are taking steps to try to remove them from the United States in a summary way. At around 12:02 a.m. Eastern Time, we ordered the government, in light of the circumstances, not to remove any member of the putative class of detainees in order to preserve our jurisdiction to consider the application. We invited the government to respond to that application as the Fifth Circuit ruled. The Fifth Circuit dismissed the detainees' appeal for lack of jurisdiction and denied their motion for an injunction pending appeal as premature on the ground the detainees gave the district court only 42 minutes to act. We now construe the application as a petition for the writ of certiorari from the decision of the Fifth Circuit. We grant the petition as well as the application for an injunction, pending further proceedings, vacate the judgment of the Fifth Circuit, and remand. So the Supreme Court's like, we're not kidding, man. We're not kidding. You actually do have to give them process. You have to actually give them the process. We are not kidding around when we said that. We weren't making a funny. And, lower court below, it's like, yeah, we weren't making a funny. You do have to give them the process. You can't just put them on the plane. Yeah, no. The Fifth Circuit erred in dismissing the detainee's application for lack of jurisdiction. It's like, no, you had jurisdiction, but thanks. Appellate courts have jurisdiction to review interlocutory orders that have the practical effect of refusing an injunction. A district court's inaction in face of extreme urgency and high risk of serious, perhaps irreparable consequences may have the effect of refusing an injunction. So because the time frames were so tight, the failure to act was basically a refusal. Yeah. Here, the district court's inaction, not for 42 minutes, so we disagree with your record on that, but for 14 hours and 28 minutes, had the practical effect of refusing an injunction to detainees facing imminent threat of severe irreparable harm. Accordingly, we vacate the judgment of the Court of Appeals. Yeah, no, you had jurisdiction to consider it. You should have done that, yeah. The Fifth Circuit entitles aliens to due process in the context of removal proceedings. Please take note, of course, however, that due process in the context of removal proceedings is fairly cursory. So when they say due process, they don't mean a full trial with a jury and everything. They mean much, much less than that. But you're still entitled to it as little as it is. Procedural due process rules are meant to protect against the mistaken or unjustified deprivation of life, liberty, or property, against mistaken or unjustified deprivation of life, liberty, or property. We've long held that no person shall be removed from the United States without an opportunity at some time to be heard. Due process requires notice that is reasonably calculated under all circumstances to apprise the interested party and affords a reasonable time to make an appearance. Accordingly, in JGG, this court explained with all 9 justices agreeing that the Alien Enemies Act detainees must receive notice that they're subject to removal under the Act within a reasonable time and in such manner as will allow them to seek habeas relief before removal. They're still entitled to a habeas proceeding from an AEA notice. In order to actually seek habeas relief, a detainee must have sufficient time and information to reasonably be able to contact counsel, file petition, and pursue the relief. The government does not contest before this court the applicant's description of notice afforded to the AEA detainees in the Northern District of Texas, nor does the assertion the government was poised to carry out removal immediately. The government has represented elsewhere. It is unable to provide for the return of an individual deported in error to a prison of El Salvador, which continues to be a craw in the Supreme Court's mouth, that the federal government isn't even trying to reverse that error. They're not even trying, which is going to piss the Supreme Court off eventually. Where is alleged that detainees face indefinite detention? Detainees' interests at stake are accordingly particularly weighty. So this is irreversible. If we deport them, we can't bring them back, which incidentally isn't even true under precedent. But we're going to pretend it is because you say it is, as we're going to beat you up on the JGG thing at a later time. Okay? Under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest removal, does not pass muster. So the notice was too short and it didn't tell you what to do. Yeah. But it is not optimal for this court, far removed from the circumstances on the ground, to determine in the first instance the precise process necessary to satisfy the Constitution. We remand the case to the Fifth Circuit for that purpose. So what kind of process is required here, again, in this context, is still a bit of an open question. Again, they could just do the normal deportation process that you would just use for any illegal immigrant. That would be fine, right? You can just deport them because they're here illegally. We have processes set up for that. You could just do that, and that would be fine. And we know what the rules are relating to that because we do them all the time. Trump over here wants to invoke the Alien Enemies Act as an express pass. Unlike, normal deportation, which we do all the time, we don't do a lot of deportations under the Alien Enemies Act. We haven't done one since at least World War II. And there weren't a lot of other examples since then either. They were very scattered as far as I can tell from the history. It's like there's like one in World War II and like one in World War I, and basically not there are very few AEA cases. So what is the process required for an AEA? Well, I don't know because we don't do a lot of them. The other ones were kind of ad hoc. That gives you some indicia maybe, but not a lot because we don't have a lot of examples. The Trump administration could, of course, just circumvent all this by just following normal deportation proceedings for a normal person who's here illegally. They could do that, but they don't want to do that. They want to use the AEA Express Pass. And the Supreme Court's like, no, not so much for the express pass for you. That's no, not so much. Yeah, not so much. Okay, to be clear, we decide today only detainees are entitled to more notice than was given on April 18th, and we grant temporary injunctive relief to preserve our jurisdiction while the question of what notice is due is adjudicated. So what you gave them was too little, but we're not going to tell you what the rules are. Again, just do the normal deportation thing would be fine. We did not on April 19th and do not now address the underlying merits of the parties' claims regarding the legalities of the removal under the AEA, which is a whole separate set of issues, right? Because not only do we have to give them notice of the hearing to deport them, but of course, the administration can only deport them if they're subject to the AEA at all, right? That would be like the difference between giving me notice of a criminal charge and the actual criminal charge, right? The government has to give me notice of the criminal charge. Also, it actually has to be a thing that applies to me, right? So the failure to give notice is a problem. Also, if the charge doesn't apply to me at all, it's a problem, right? So does the AEA apply to these people at all? Also unsure whether it applies to these people at all because, well, we still have to fight through all these issues too. So many, many fun issues to be found. The dissent disputes both the court's jurisdiction and the availability of classified relief. We do not find this reasoning persuasive. First, we reject the dissent's characterization of the events that transpired on April 18th, which led to the question of our jurisdiction. District courts should approach requests for preliminary relief with care and consideration, but exigent circumstances may impose practical constraints. So sometimes you got to move it. You got to move it. And, that's a thing. Preliminary relief is customarily granted on the basis of procedures that are less formal and evidence is less complete than a trial at the merits. The purpose of such relief is merely to preserve the respective positions of the parties pending further proceedings. It's an injunction. Typically, they are meant to just freeze things in place while we try to figure everything else out. And no exception here. In this case, the record before the district court, although limited, indicated that removals of the putative class members were likely imminent. Yeah, seemed like what the government was trying to do. I mean, they moved them to the airport and on the plane, so kind of seems like they were thinking about getting them out of the jurisdiction. Kind of seems like there were some indicia along those lines. The detainees attached 4 declarations to their emergency motion. In one, for example, an attorney relayed a detainees report that immigration officers had reported and informed them that they'd be deported either today or tomorrow. In a second, a nonprofit director described conversations with family members of detainees and linked to video of detainees holding notices of removal as evidence the detainees were being removed. I mean, that would be pretty strong indicia, right? We're not planning on removing them, but they're holding notices saying that you are in their hands. That's kind of a clue. Importantly, the relevant question for purposes of jurisdiction is whether, at the time the court was called upon to intervene, the district court's inaction had the effect of refusing the injunction. In their application to the court, detainees represented that many individuals had already been loaded onto buses, presumably headed to the airport. Shortly thereafter, the government represented on the record in federal court that reserved the right to remove detainees after midnight. We have the power to issue injunctive relief to prevent irreparable harm to the applicants and preserve our jurisdiction. Now that the Fifth Circuit has ruled, our certiorari jurisdiction also supports review in the ordinary course. Yeah, we're going to be able to do something about this, Yeah. Finally, this court may properly issue temporary injunctive relief to the putative class in order to preserve our jurisdiction pending appeal. And then there's a footnote. We know that the district court recently denied class certification as to the detainees' underlying habeas claims challenging the validity of removal under the AEA. By its own terms, the district court's order is automatically vacated by our order granting a writ of certiorari. How nice. So, yeah, the district court already said if they grant a cert, then it's vacated. So that's vacated. That's nice. And in any event, the district court's order primarily addresses the detainee's ability to challenge the validity of the AEA removal on a class-wide basis. The application before this court seeks only to vindicate notice rights on a class-wide basis. To the extent the district court order addressed due process, the district court concerns as a property of class-wise relief focused on considerations downstream of initial notice necessary for detainees to bring in substantive claims. So basically, you're just completely off point. Lower court, you're just off point. But that's okay. We're here to help. Named applicant AARP and WMM assert that they're at imminent risk of being classified as alien enemies and removed from the United States, which, given the notice in their hands, seems like a pretty good thing to argue that that's true. But the record does not indicate they have received any formal notice of removal under the AEA. The named applicants, along with putative class members, are entitled to constitutionally adequate prior notice to any removal in order to pursue appropriate relief. Although the putative class members may ultimately take different steps to protect their own interests in response to such notice, the notice to which they're entitled is the same. And because courts may issue temporary relief to a putative class, we need not decide whether a class should be certified as to the detainee's due process claims in order to temporarily enjoin the government from removing the putative class members while the question of what notice is adjudicated. So, yeah, whether or not the class should be certified or not, we can still grant temporary relief to the class, which is pretty hilarious. Because, again, we're just trying to freeze things in place while we're trying to figure out what's going on. We recognize the government has agreed to forego removing the named petitioners pursuant to the AEA while their habeas petitions are proceeding. But we reject the proposition that a class action defendant may defeat class treatment if it's otherwise proper by promising as a matter of grace to treat the plaintiffs differently. So basically, we're not taking your word for it, right? You say that you're not going to deport any of them. But you know what? We're not required to accept that representation, and we're not going to. You say you're not going to, no problem. Here's an order also ordering you not to. So, hey, belt and suspenders approach for everybody. Yay. And we're skeptical of the self-defeating notion, the right to notice necessary to actually seek habeas relief must itself be vindicated through individual habeas proceedings, somehow by plaintiffs who have not received the notice. Very cheeky line, right? Like, yeah, we're skeptical that the right to seek notice must itself be indicated individually, even when some of them have not received notice. Very, very cheeky. The application for injunction pending further proceedings is granted. The motion for leave to file supplemental appendix under seal is granted. Additionally, applicants suggest the court treat this application as a petition for writ of certiorari. Doing so, the petition is granted. Right? So it's like, that's fun. Right? So it was an injunction proceeding. It was an injunction, but in the alternative, how about you treat it as a petition for writ of certiorari? Okay. We treat it as a writ of certiorari, and now we're going to decide as a writ of certiorari. And here's your decision. Here's your sign. They're still not getting the memo, man. They're still not getting the memo. That is hilarious. The Supreme Court treating it as a petition for cert, granting it, and then deciding it instantly? Holy shit, dude. Holy shit, dude. Take the L. Take the L, man. Damn. The judgment of the Fifth Circuit is vacated and the case is remanded to the Fifth Circuit. In resolving the detainee's appeal, the Fifth Circuit should address all the normal preliminary injunction factors, including likelihood of success on the merits, as the named plaintiff's underlying habeas claims, that the AEA does not authorize the removal pursuant to the proclamation, and the issue of what notice is due as to the putative class due process claims against summary removal. The government is enjoined from removing the named plaintiffs or putative class members in this action under the AEA pending order by the Fifth Circuit and disposition of the petition for writ of certiorari if writ is timely sought. So unless we dissolve the injunction, it ain't being dissolved, baby. You have an injunction from the Supreme Court. Deal. Should the petition for a writ of certiorari be denied, this order will terminate automatically. So in the event that, there is a petition and the petition is denied, then, fine. In the event the petition for the writ of certiorari is granted, the order shall terminate upon sending the judgment of the court, which I'm not sure you really need to say that part out loud, but, fine. So if we deny cert in the future, then this order dies. And if we grant cert, then obviously it's going to be replaced with whatever new exciting order we have to issue. The government may remove the named plaintiffs or putative class members under other lawful authority, such as, for example, bog standard normal deportation proceedings. No one has been denying this the entire time. I have not been denying this. I've never said anything even remotely contrary to this, ever. All you have to do is just deport them using the normal, regular deportation proceedings that you just normally use for a person just being here illegally generally. We have those set up. We've been doing deportation proceedings for a while. It is not new. It is not a new thing. We have entire administrative law judges just for this. We call them immigration judges, but whatever. We have immigration law judges. You can just give them the normal hearing that's due for any illegal alien. Just do that. Give them their hearing. You can probably do it in 20 minutes flat. You can probably do it in groups, okay? Because the standards are so fucking low for immigration proceedings when it comes to due process, right? It's basically bottom of the basement, bottom floor shit. So look, all you have to do is just do the normal deportation. Forget about the AEA. Just forget about it. Just use we're deporting you because you're here illegally. Just do that. And then give them the hearing for the immigration judge and then deport them. Easy peasy. Easy, no problem. But, the Trump administration doesn't want to do that for whatever reason. They keep wanting to do it, well, they think the easy way. They thought the AAA was the easy way, but the Supreme Court has basically told you multiple different ways that, yeah, basically not so much. You might win under the AEA eventually. You might win under the AEA someday, but by then you could just deport them. Just deport them normally. Just do the normal deportation thing. Just do that. And then, that'll be fine. It is so ordered. Yeah. And then there's a dissent, or Justice Kavanaugh concurs. We'll read the concurrence, I guess. I understand and agree with the court's decision to grant temporary injunction. The injunction simply ensures the judiciary can decide whether the Venezuelan detainees may be removed under the Alien Enemies Act before they're in fact removed. What a nice idea, right? Let's decide whether or not the AEA applies to them. And assuming it does, let's give them the hearing that they're entitled to, which might not be much, right? Maybe it's summary. It's, but still they're entitled to habeas review. So, do that. The underlying legal questions the court may need to decide before the removals occur include whether the Alien Enemies Act, as distinct from, and this is the important part, pay attention, Trump administration, as distinct from the ordinary removal process under the INA. Just use the normal process under the INA. Just do that. It'd be fine. So whether the AEA authorizes removal, and if so, what notice is due. Several federal district courts have also issued conflicting rulings under the underlying issues, which isn't particularly surprising because there's not a lot of AEA law out there, because there's not a lot of AEA cases, because, it doesn't come up very often. It's whatever, it's fine. The executive branch and detainees agree the urgency and import of these legal questions. The executive branch has represented that in this case is important for American national security, and it's critical to remove the TDA members subject to the proclamation quickly. Well, I mean, you could just deport them like a normal person. For their part, the detainees have explicitly requested this court move fast and grant cert before judgment. Yeah, probably. I mean, they just want to go straight from district court to the U.S. Supreme Court. That's cert before judgment. When they say cert before judgment, they just mean skip the Court of Appeals. Yeah. The circumstances call for prompt and final resolution, which likely can be provided only by this court. Facts. At this juncture, I'd prefer not to remand to lower courts and further put off the court's final resolution of the critical legal issues. Rather, consistent with the executive branch request for expedited review, as detainees themselves urge, I'd grant certiorari or a prompt briefing, hold oral argument, and then resolve the legal issue. I suppose we could do that too, but I think the Supreme Court is trying to encourage the Trump administration to find a different path. It's like we can slow you down. Kavanaugh would prefer to resolve the issue under whether or not they're subject to the AEA at all, and assuming they are, what the habeas issues related to that are, but whatever. So yeah, that'd be fine. All right. Then we got Justice Alito with Justice Thomas dissent. So apparently we get a 7-2 on this one. I cannot join the decision of the court. First and most important, we lack jurisdiction and therefore have no authority. Is this coming down to whether the TRO is really a TRO or not? Probably. I don't want to have this fight again. If the dissent is going to come down to whether the TRO is really a TRO, I just don't want to have this fight again. We've already had this fight like 3 or 4 times in the context of immigration cases. I just can't be bothered to have another fight over whether or not the TRO is really a TRO or not. I'm tired. I just don't want to have the same fight again. Second, even if we have authority, the applicants have not satisfied the requirements for issuing of injunctive relief pending appellate review. Third, grant cert before a decision on the merits has been made by a district court or court of appeals is unwarranted. Well, I think the Supreme Court's trying to indicate it's not fucking around. I think that's why they're doing it. I'm not disagreeing with you in the abstract on that last point. It is pretty much a kick in the balls. I don't know if it's ever happened before. It might not have ever happened before. I think the Supreme Court's kind of pissed. I think they're at least pissed in part because of how you've been jerking their chain on JGG. I think they're kind of pissed off about JGG. They feel like their orders are being defied because the Trump administration doesn't exactly seem to be making best efforts to return JGG back to the United States. I think they're also a little pissed off that it's like, yeah, we're not trying to remove them. As we have the notice of deportation papers in hand, and as we're loading them onto the plane. So I think the Supreme Court's a little pissed. I think they're a little pissed. Jurisdiction is the power to declare the law. Without jurisdiction, the court cannot proceed at law. So in order for us to do anything, we must assure ourselves we have jurisdiction. Okay. The court's theory of jurisdiction is as I follow. Under 28 U.S.C. 1254, we have jurisdiction to review a case that's properly before one of the federal courts. This case was properly before the Court of Appeals before the Fifth Circuit because the 2 habeas petitioners took an appeal from the district court that refused to issue the injunction. Although the district court never actually issued such an order or said it would do so, the district court constructively construed the denied injunctive relief by failing to act under circumstances when prompt intervention was urgently needed. This theory rests on a mischaracterization of what happened at the district court. I do not dispute that the district court's failure to act expeditiously may, in some circumstances, have the practical effect of refusing an injunction and thus entitled to take the party to an interlocutory appeal. But that principle does not apply here when the district court had no reason to think that either AARP or WMM was in imminent danger of removal. The majority strongly disagrees with you, sir. They couldn't help noticing that apparently they loaded them onto the plane, sir, before taking them off the plane and bringing them back to facilities. There seemed to be some indicia along those lines, sir. I don't know about that. The record at the time contained only sketchy evidence about any imminent threat to the members. The court took the entirely reasonable position it would wait for the government to respond to the applicant's request for the TRO before acting. The court set a very short deadline for the following of the response. Well, sometimes that's what happens. Under the normal rules of procedure, you get like a lot more time. Normally federal courts in particular can move somewhat at a glacial pace. Normally they can move at a somewhat glacial pace. But, sometimes the court's like, how about like right now? And you get the call at 2 a.m. and you have to wake your attorney ass out of slumber and, write some documents at 2:30 in the morning or some bullshit. Or you're a federal judge who gets waken up at 2:30 in the morning. Lame. But, it happens sometimes. The court asserts the district court failed to act for 14 hours and 28 minutes, but that's misleading. Okay. Here's what actually happened. Sell me. On the evening of April the 17th, lawyers for AARP and WMM made a phone call in which they demanded to talk to a judge immediately and have the judge issue the order. As the district court has since correctly noted, judges are generally not permitted to consider such ex parte communication. Not generally, but TROs, can be a bit different. So the judge issued an electronic order admonishing the attorneys and stating that to the extent either party seeks immediate emergency relief, it may file a motion to do so. If the motion is filed, the opposing party shall have 24 hours. Yeah, but we didn't have 24 hours. That was the problem. The district court wasn't like completely out of pocket. The district court was probably a little pissed at being called at 3 a.m. Federal judge being woken out of its slumber by a party's like, I need your answer right this second. District court was probably a little pissed. But, some days, man. Some days. The Supreme Court said, yeah, you should have taken that phone call. Lame. Thus, when attorneys for AARP and WMM filed the renewed motion for a TRO at 12:34 a.m. on the 18th, they are fully aware that the district court intended to give the government 24 hours. But in that motion, attorneys said nothing about a plan to appeal if the district court elected to wait for a response. It was not until their 12:48 p.m. motion for immediate status conference, the attorneys suddenly informed the court they had filed appeal if the district court did not act within 42 minutes. I mean, that is pretty cheeky by the attorneys. I have to give partial. I'm not sure who I'm giving partial credit to at this point. I'm not sure who I'm giving credit. Am I giving credit to the district court? Am I giving credit to the dissent? I'm not sure who I'm giving the credit to. But it's like, okay, I filed the motion. Also, I need your answer in 45 minutes or less. What am I, at Domino's? Right? What am I, at Domino's? I guess today you were a Domino's. You were supposed to put the fries in the bag. Didn't pay to get out of bed this morning. Not that they gave you a choice because they woke you up. They filed the TRO at 12:34, which means they called you at like 10 p.m. or something. How'd they get your number? How'd you get this number? Would be the question I'd be asking as the federal court. How on God's earth did you get my number? The attorneys then filed their appeal at 3:02, just 133 minutes after they put the district court on notice they'd seek relief. Whether or not the actions taken by the attorneys are thought to justified under the circumstances, delivering such an ultimatum to the district court, act on my motion in a complex manner within 42 or 133 minutes or I'll file an appeal, represents a very stark picture of what is usually regarded as acceptable. I mean, to be fair, that's true. Like under normal circumstances, if an attorney tried to do this, if under normal circumstances, if an attorney tried to do this, the district court would just kill you. They would just kill you. They would get the head man. They would get the head man, and they'd find a chopping block, and they'd just have your head removed in the back alley of the federal courthouse. I mean, facts, though. Facts. It's like, but the Supreme Court is really pissed. You know how I told you, like sometimes I told you about the grounds? You know how I told you sometimes about the grounds for like interlocutory review in general? You remember when I told you that discussion about what are the reasons that you do interlocutory appeal? And they're basically like kind of 4 reasons that basically boil down to when it sort of ends at the end of the day. One is it's a completely novel question of law. And so that is, that's a big deal. So it would make sense to adjudicate it now to save some time. So completely novel application of completely novel law is ground one. Ground two is a matter of unique importance, unique national importance, extraordinary importance, right? A case that has major, massive, seismic ramifications. Ground number three, it involves a lot of people. A lot of people are gonna be hurt. Or ground number four, the court is just really pissed. Now, normally, ground four, the court is really pissed. Normally, it's the court is really pissed at the lower court on ground four. Normally, it's they're granting review, not because of your case really, but because they just really want to beat up on the lower court that day. They are just really, really pissed. Well, the Trump administration has managed to expand ground four, and a lot of this is being done because they're just really pissed at the administration. They're just really, really pissed. Not that they didn't have the other grounds anyway. I mean, because the AEA is basically novel because it's never used. So basically, they got all four. They basically got all four. Is why the Supreme Court's doing this. It's basically a novel issue of law because there's not much precedent on it. It's a case of unique national importance because immigration and stuff, and it affects maybe 20 million people, depending on how we're counting things. It involves a fight between the branches and power balances, and also the court's really, really pissed. So basically, you found all 4 reasons the court's to grant review. That's a bingo. That's epic. You just managed to trigger every possible reason. You triggered all the reasons. Wow. Yeah. So normally an attorney doing this would have you destroyed by every level of court. The federal court would chop off your head, and then the court of appeals would put it back and chop it off again, and then the U.S. Supreme Court would bury you upside down in a bad part of town, and you'd be putting fries in the bag for real. The fact that none of that is happening, the fact that the Supreme Court is not destroying this attorney and every hope he ever had and dream as a warning to others, putting his head on a pike outside the Supreme Court, the fact they're not putting the attorney's head on a pike, it's I don't know where the attorney got the balls to do this, incidentally. I mean, that's some big boy. I don't know where you get that level of balls to do that. That's a lot of balls. Let me call the judge up at like 10 o'clock at night, ex parte, and then let me file an order and demand that he do what I want in 45 minutes or else. Where do you get that level of balls? And then you're right. Holy shit. Faced with applicants' extraordinary demands, the district court proceeded in an entirely reasonable manner. The court characterizes the district court's behavior during the period as inaction, but in my judgment, that's unfair. Rather, as the judge has noted, he's working with the utmost diligence to resolve the important and complicated issues presented by the motion as quickly as possible. The judge explained that he had not yet ruled because he could not shirk his responsibility to decide the complicated issue of law. That's okay. The Supreme Court's got your back. Right? The district court, not unreasonably, is like, this is a very complex issue. There's not a lot of precedent. You want me to come up with a decision in 45 minutes? I'd be lucky to come up with a decision in 45 days. What the fuck? Right? And it's like, how am I supposed to do that? How am I supposed to do that? Supreme Court's like, don't worry about it, fam. We got your back. We got it covered. Holy shit. And the judge was prepared to issue an order as soon as practical after the government filed its response shortly after midnight, if not sooner. We should commend this careful approach, not criticize it. Yeah. District court, this wasn't really your fault. This was not your fault. I'm sorry. This was not your fault. This is the administration's bullshit, and you're just caught up in it. I'm really, really sorry this is happening to you. This is unfair. But in this case, a district court judge is deemed to have constructively denied an injunction by failing to act within the space of a little over 2 hours on an application that required consideration of an important and difficult question and was supported by a factual submission, as I'll explain below, was very, very weak. Under these circumstances, I cannot agree that the district court's failure to act amounted to constructive denial. You know, I understand that point of view. That is a perfectly reasonable opinion, except for the fact the Supreme Court's really pissed. They're just exceptionally pissed. They feel like they're being jerked around. They feel like them and the lower courts are jerking them around. The Supreme Court is pissed. You know, if I were the Trump administration, I'd seriously consider bailing at this point, because, dude, like, how much writing on the wall do you need, Trump administration? The Supreme Court is pissed. Now, I understand they're using very, very sophisticated legal language, but even the Supreme Court is letting you know. They're letting you know this is probably not going to end well for you. Okay? The odds-on favorite of, in the end, the Trump administration gets substantively what it wants out of the Alien Enemies Act is not the most likely resolution at this point. The Supreme Court is hinting pretty hard. They are trying to telegraph to you in every way, this is probably not going to end well for you. If you push this and you take this to the end, we're probably going to embarrass the shit out of you. So now would be a really good time to, slink away, save some face, and pretend like the whole thing never happened. Also, if you could return JGG to us, that would also be great. Thanks. The Trump administration is playing the fuck around and find out game really, really hard right now. On this. Yeah. Good times. This must be the stupidest comment I've ever seen in chat. This is pretty fucking stupid. AEA is legal according to the Pennsylvania judge. Do you know why that comment is stupid, or do I have to point out why it's stupid? Do I really have to sit here and explain to you why this is a stupid comment? Or do you know why it's a stupid comment? Do you want to retract? Do you know why it's a stupid comment? Do I have to spell it out for you? Holy shit. Man. Here's a clue. Who is the Pennsylvania judge's boss? What do they think? As I've mentioned, the factual support provided to the district court was weak. The court claims that the facts presented to the district court on April 18th show there was an emergency entailing a high risk of serious, perhaps irreparable conflicts. But it's important not to conflate the information that was in the record on April 18th with the new information that was presented to the court several days later. Yeah, well, be that as it may. Don't read the chat? Fair enough. I wouldn't have taken the time. I just thought it was a particularly inept comment. It's like, there's a Pennsylvania judge who thinks the AAA is totally cool. I don't deny that's true. I just think it's a stupid comment because we're reading something from that court's boss that, has some reserved thoughts on the issue. That was a fucking retarded comment. I couldn't resist the bait. Aren't I supposed to have members only? I can't restrict members only inside the streaming software I'm using. So never mind. It doesn't matter. Also, don't tell me how to run my stream or something. I don't know. Whatever. It's fine. The record before the district court on April 18th, which was the same record as before us on midnight of that date, included no concrete evidence that any removals were so imminent that a ruling had to be made immediately. The applicant's factual support consisted. I'm sorry, Mandy. I'm just tired. That was snarky and undeserved. You're a good moderator. I'm sorry. The applicant's factual support consisted of 6 sworn declarations and a photograph the applicants asserted was an image of a notice removal. But neither the declaration nor the photograph showed extreme urgency. Uh-huh. The declaration certainly did not need to show the action was urgently needed to protect AARP or WM. The government had represented a district court that would not remove either of those men, the only parties who were indisputably before the court while their habeas petition was pending. And the 2 declarations concerning those individuals include no allegations about immediate removal. Indeed, the declarations concerning them were signed on April 15th prior to the government's representation. They would not be removed while their habeas petitions were pending. Well, yeah, but we're not really going to take your representation forward at face value anyway. Yeah. No, I was in the wrong. That's fine. I was in the wrong. It's fine, Mandy. I'm sorry. And the declarations concerning them were signed. Yeah, we read that part. As a result, the declarations were outside and provided no support for their claim that either AARP or WM was threatened with removal on 18th or 19th. Uh-huh. And there's a footnote. The government unequivocally told the district court it did not presently expect to remove. Presently. Is that like a Nick Rekieta presently? Like literally at this exact moment presently? Yeah, no wonder we're not taking your word for it. Did not presently expect to remove AARP or WMM under the Alien Enemies Act until after the pending habeas had been resolved, and would update the district court if that changed. Well, update them as the plane is in the air, maybe? Update when? And in their application for relief before the court, the applicants did not assert that AARP or WMM in particular are at risk of being removed. You know, can you think of any reasons why the Supreme Court might not necessarily want to take the administration's word for it at this point? They're feeling a little jerked around. They're feeling a little jerked around. The government later confirmed its filings before the court as agreed not to remove pursuant to AEA those AEA detainees who do file habeas claims and claim the named applicant. Well, that's good news because the Supreme Court just did it in order too. So we're glad that you agreed to the order. That saved a lot of time. The remaining evidence in the record at the time concerned only unnamed members of the yet as uncertified class. And the 4 declarations concerning those individuals, only one said anything about when removal might happen. In the declaration, a lawyer swore that she'd spoke on the phone with an unidentified Venezuelan man who said that ICE had informed them that they'd be deported either today or tomorrow to Venezuela. In other words, the most specific piece of evidence in the record was a double hearsay statement. Yeah, but that's where we're at. That's the level of how pissed we are. That's the level of how pissed we are that will take one person's double hearsay statement over the representations of the federal government. That's how pissed we are. On the one hand, we have the administration. On the other hand, we've got a vague conversation in a double hearsay. Which of these are we going to find more reliable? Apparently, we've decided to find the double hearsay more reliable, and I understand completely. That's how pissed we are. The Supreme Court is so pissed they can't even see straight anymore. That's how pissed they are. Outside of that, none of the remaining declarations said anything about removal. It was 7-2. It was 7-2. 7 members of the Supreme Court said, yes, we'll take the double hearsay over the representations of their attorney in court. Holy shit. Can you imagine that? How fucked up does your case have to be? How fucked up does your case have to be before, on the one hand, you've got an attorney say, yes, I represent the U.S. government, and I'm here to tell you, on behalf of the U.S. government, we will not deport these people. And on the other hand, we've got some guy with a double hearsay statement, and the 7 members of the Supreme Court are like, yeah, we're going to credit the double hearsay over you. Man, you are having a bad day. Woof. Woof. They merely stated that certain aliens were receiving deportation notices, but has not claimed the notices specified when the removal might occur. And the image of the document labeled "Notice and Warrant of Apprehension or Removal under the Aliens Act," which applicants termed a removal notice, likely said nothing about the time. Other than these declarations, the court was left with unsupported attorney assertions in the application. Holy shit! When you put it that way, yeah, yeah. I mean, this is bad for the federal government. This is so bad, man. Holy shit, dude. Yeah, all we've got is an attorney who's just saying things, but there's no like support for their things they're saying. And we've got one Venezuelan who heard from somebody in a double hearsay. Yeah, we're going with the unsupported double hearsay. We're also backing the play. We're also backing the play of the attorney who called the judge at 10 at night, then filed a notice at 12:30 the next afternoon and demanded an answer in 45 minutes or less. So we're backing that attorney, and we're backing the double hearsay attorney. Oh, damn, man. 7-2. Ignoring these deficiencies in the record before district court, the court relies on information the district court that is not on the record, namely statements made by the government's attorney in a hearing in another case that was held in Washington, D.C. during the evening of April the 18th, well after applicants filed their appeal. Well, yeah, I mean, we're going to, what the U.S. government says things, we're going to kind of, yeah. And evidence that we received several days later. But in evaluating whether the district court effectively refused to issue the injunction, we must consider the facts as they are known to the court at the time. Do we, though? Do we need to consider the facts that were known at the time? Normally, that's correct. Is it correct now? I don't know, ma'am. I don't know if it's correct now. For these reasons, I agree with the unanimous Court of Appeals panel. District Court did not constructively deny the application for injunction. As the panel stated, there was no reason to doubt the diligence and ability of the District Court to act properly under the circumstances. And the failure to issue the requested ruling within an extraordinary short period specified by the applicants cannot be reasonably viewed as effective denial. Yeah, normally that's true. And apparently there's more footnote. Although the attorney had said the Department of Homeland Security reserved the right to remove people tomorrow, he repeated numerous times that no flights were planned for the 19th. Planned, he says. The attorney's statements show that there was a possible future injury, but the injury was not certainly impending. Yeah, we don't believe you. Even if the district court had denied the applicant's motion, there would be no grounds for reversal because the applicants failed to satisfy the requirements for emergency injunction, one of which is showing the likelihood of success. And here, in order to obtain what the application sought and what this court now provides, relief for the members of the class that applicants has to be certified, applicants had to show that they were likely to establish that class relief is available in a habeas, and if such relief is available, the standard requirement for class certification could be met. There's a footnote. The court asserts that courts may issue temporary relief to putative class without deciding whether a class should be certified. In support of the proposition, the court cites no precedent. Indeed, it cites to a treatise that provides no substantive reasoning. Well, the Supreme Court just created it out of nowhere. Yeah, why does the Supreme Court think that it can do that? It just said it does. It just said it can. Just now. Yeah, that's one of the perks of being the perks of being the Supreme Court, right? I heard a wise man once say that I could grant this kind of relief. What wise man? Just me, just now. It's good to be king. In my judgment, applicants were not likely to prevail on either of these issues. First, it's doubtful that the class relief may be obtained in a habeas. We've never so held, and it's highly questionable whether it's permitted. Fair enough. But for the moment, the Supreme Court doesn't really care. Also, are you sure you don't want this to be a class? Because that feels like a real pain in the ass. Do you really want every single one of these people to individually file their own habeas? I mean, that would be the alternative. Do you really want, instead of one big, beautiful habeas, several thousand smaller habeases? Do you really want to do that? I don't know, ma'am. Sounds like a pain in the ass. Although habeas proceedings are classified as civil, the federal rules of civil procedure apply only to the extent the practice in habeas previously conformed to the practice in civil actions. And in accordance with Rule 81, we acknowledge that some federal rules are inapplicable in habeas. In Harris versus Nelson, for example, we held Rule 33 concerning interrogations does not apply in habeas proceedings because it has no analog in historical habeas practice and is a poor fit in a habeas proceeding. Among other things, we know that the prevalence of fact-finding in habeas proceedings was a relatively recent development, and the specific scope of Rule 33 was ill-suited. I think I'm going to shave. You know, it's May. I think I'm tired of the beard look. I think I'm going to shave. Let me know if you think I should shave or not. There are specific reasons to believe that Rule 23, which authorizes class actions, is inapplicable in habeas. Neither courts nor commentators have found historical support for the practice. One commentator writing in 1968 noted that no class has been found which anything resembles a class action used in habeas. 2 years later, another commentator observed that class actions for habeas corpus relief have rarely been attempted, perhaps because Rule 81 seems to bar the application of the civil class action rule to habeas. Indeed, yeah, a habeas in a civil proceeding is kind of weird now that you mention it. That is pretty weird, actually, now that you mention it. But, be that as it may, that's where we're at. Indeed, there appears to be some historical debate over even whether joinder was permitted in habeas practice. Despite the lack of historical support, some lower courts have held that our decision in Harris sometimes permits procedures that resemble those used in a class action. Maybe we're just inventing new procedures as we go. We're just creating them out of nothing. As noted, Harris held that Rule 33, which concerns interrogations, does not apply in habeas, but the court also observed that habeas courts may fashion appropriate modes of procedure by analogy to existing rules or otherwise in conformity with judicial usage, where such modes of procedure are necessary to the habeas corpus jurisdiction and the duty to exercise it. On this ground, Harris held that a habeas court may use its authority under the All Writs Act to fashion a procedure resembling an interrogatory to the extent that such an instrument is needed by the court to perform its duty to summarily hear and determine the facts and dispose of the matter as law and justice may require. Based on the decision in Harris, the Second Circuit held that while Federal Rule of Civil Procedure 23 does not itself apply to habeas, a multi-party proceeding similar to Rule 23 class action is sometimes allowed. And it concluded this proceeding was appropriate in the unusual circumstances presented by this case. This reading of Harris is highly questionable. Where a particular rule does not apply in habeas, a court cannot circumvent the limitation simply by saying it's importing the same feature under a different rubric. Why not? It's the Supreme Court, right? Harris concluded that something like an interrogatory was allowed because it was needed under the circumstances to help the habeas court carry out the duty clearly imposed by law that is determined of the facts, the material of the claim made by petitioner who's before the court. The situation here is different. No provisional law imposes on the habeas court the duty to determine facts or decide legal issues regarding the parties who are not before the court. Yeah, but do you really want to do this piecemeal? I guess we could. As a general matter, the class action device is uniquely ill-suited for habeas proceedings, which often turn on individualized and fact-specific determinations. Well, it depends what we're trying to decide, to be honest, but okay. Even if something resembling a class action could be used in the habeas, it's very questionable whether requirements for class certification could be met in this case. Rule 23 provides that named plaintiffs may sue as a representative class only if, among other things, the claims or defenses of the represented parties are typical of the claims of defenses. Well, for the moment, they at least are. They're typical enough. And when a court certifies a class, the court is supposed to define the precise claims that will be adjudicated on a class-wide basis. That ensures that only claims that are adjudicated in class action are those that bring the class in common and for which the named plaintiffs are typical representatives. Here, however, the main interim relief sought on behalf of the putative class, adequate notice for plans removal under the AA, and opportunity to contest such removal is not needed by either AARP or WMM, who have been pending habeas, and the promise will not be removed. Yeah, we're not buying the promise. The promise is not enough for us right now. Get fucked. For this reason, their situation differs critically from that of many putative class members since they have no personal stake in how the court resolves the question. Bullshit. The court responds to this problem by suggesting that a class action defendant may not defeat class treatment if it's otherwise proper by promising as a matter of grace to treat the claims differently. But the court provides no analysis suggesting class certification here is otherwise proper, and instead asserts it can ignore the question of class certification at the preliminary stage. Yeah, that's what they're doing. They're ignoring it for the moment. They don't care. They don't care. And in any event, the record does not suggest the government is treating the named plaintiffs differently as a matter of grace. Rather, it's doing pursuant to general policy against removing AEA detainees when they have pending habeas petitions. We've told the district court they may certify a class only after conducting a rigorous analysis. Yeah, but that's this is why the Supreme Court's here. They've got your back, right? I mean, the district court, it's like the district court would be, cautious. The Supreme Court's like, that's okay. We got your back. We got it. We got it. We're just going to help you. We're going to help you out. We're just going to declare things now. Yeah, the Supreme Court is being pretty interventionist at the moment. And basically, it's like they basically pulled the we are the district court kind of thing at the moment. It's like we're all the courts. We're all rolled up into one. Hold my beer. Fuck you. On April 18th, the district court had no time to engage in such analysis. As a result, it cannot be said the court abused discretion. Yeah, well, be that as it may. The district court has since had time to conduct the rigorous analysis that our precedent require and conclude class certification would be improper here. Where are we? I've lost my place. The district court has since had time to conduct rigorous analysis our precedent requires and conclude class certification would be improper. That development makes relief in this court today all the more extraordinary. Purporting to exercise appellate jurisdiction, which, that's something that could be appealed, I guess, the court issues preliminary relief to a putative class the district court has explicitly refused to certify, and does so without providing any steps of analysis suggesting district court's analysis of class certification was incorrect. Yeah, well, whatever. Instead, is substantively engaged with district court's order. The court asserts that the order makes no difference because it primarily addressed the detainee's ability to challenge the validity of the AEA removal on class-wide basis, whereas the application before the court seeks only to vindicate notice rights. But district court order did not address the notice question. In addition to explaining why the applicants cannot explain their final merits claim as a class action, the order explains at length why the applicant's claim regarding notice rights also cannot proceed on a class basis. Among other things, the district court observed that due process is by its very nature individual, a proposition plainly supported by a precedent. In any event, the district court also offered several general reasons why class relief would be inappropriate here, and those apply equally to the applicant's claim regarding notice rights. The court today issues temporary relief without engaging in any of that analysis, and once more asks the Fifth Circuit to finally adjudicate the notice of rights members of the putative class without asking the court to do its own analysis regarding class certification being appropriate. Clearly, the court would prefer to ignore the important step of class certification. Yep, that's basically what's happening, and skip directly to adjudication of the class members' rights. The federal rules do not permit such a shortcut. Oh boy, if only there was some way to determine what the federal rules do or do not permit. Whoever should we ask? Law. Instead of merely ruling on the application before us, which asks emergency relief pending appeal, the court takes the unusual step of granting certiorari before judgment. That's pretty unusual. Summarily vacating the judgment below. Yep. And remanding the case to court of appeal with directions regarding issues that it should address. From the court's order, it's not entirely clear whether the court has silently decided issues that go beyond the question of interim relief. But if it has done so, today's order is double extraordinary. Granting cert before a court of appeals has entered judgment is a sharp departure from usual practice, but neither the court of appeals nor a district court has any time to consider the merit questions. Yeah. It's fun. It's fun. It's fun. We have said more times than I care to remember that we're a court of review, not first view. Even on the court's reading of what happened below, all the district court and the court of appeals decided was applicants were not entitled to temporary injunctive relief. If the court has gone beyond the questions, blazed a new trail, it has plucked the case for the district court to decide important issues in the first instance. He's not entirely wrong. He's not. Yeah. To my eyes, that looks like too much of an expansion of our original jurisdiction. I therefore much respectfully just say, Alito's not wrong. Alito's not wrong, and that means the court is pissed because 7 members were like, "Fuck it." Yeah, that's basically the response. That's basically the response to Alito is fuck it. That was a pile of fun. Let us read some of your member chats. Once I remember where the member chat button is so that I don't read the stupid. I'll go into YouTube's backend where I can filter the chat out so I don't see the stupid. All right, let's see. What is the member chat saying? Let's see. Making law, that's Congress's job. They've made no law. They're just trying to interpret the law. That's what they do. Someone said the beard looks good. And that's basically all the member chats. Okay. So not so much on the member chats today. Okay, fair enough. All right, guys. Well, I guess I'm going to go ahead and sign off. This has been fun and exciting. So yeah, the administration continues to get beaten up on this. Again, by the way, it's just really simple. Just do the normal deportation proceeding. Just do the normal deportation proceeding. Just, do that and it'll be fine. Then deport them. It'll be fine. Just do the normal thing. So all that stuff. So that brings us to the end of the discussion of this. We'll be on tomorrow, I believe, at noon with somebody. And Miss Shorty, I believe, tomorrow at noon. And we're also going to have an interview, I think, with Vinny from Court TV, I think, at some point in the relatively near future. So that will be exciting. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.